The case between the Pretoria High School for Girls governing body and the Gauteng Education Department was now temporarily struck from the roll after the SGB requested that Judge Nkosi Mota recuse himself, apparently over political statements that he's made. Let's first talk about that and what this means for this matter. I mean, will it still be heard? Where to from here?
Good day, Onati. Thank you for having me. So yes, I believe that the matter has since been struck due to political utterances that have been made by the judge. You know, the SGB are entitled to request that the judge recuse himself if they have the reasonable belief that the judge may be biased, which it seems that they've taken that view. Whilst the matter may have been struck, they are entitled to bring it in the ordinary course. I believe that it was in urgent court today, but like I said, they are entitled to bring it in the ordinary course.
So let's talk then in terms of what the SGB actually wanted, the court to do. It wanted the court to compel the Gauteng Education MEC Matemo Chulwane and the department, in fact, to release that investigative report into the alleged racism at the school after, you'd recall, of course, those 12 learners were suspended in July. The findings were dropped by the school in August into those allegations of racism linked to the involvement of the WhatsApp controversial, statements that were made there. How strong a case do you think the SGB has here?
I do believe the SGB do have a relatively strong case. They are at the forefront of this matter. They are entitled to a full report. Whilst they might be able to compel the GDE to provide that report by going to court, they may also want to take the opportunity to go through the PIA Act and obtain it through that manner. But they definitely are entitled to this report, and if they want to review the report and possibly set it aside, they are entitled to do so, but they would first need to obtain a full copy of the report.
And one of the things, of course, that the SGB is saying is that in its investigation, in its private investigation, the Department of Education went beyond its scope, which we saw, of course, leading to the principal and the deputy principal being found guilty of, misconduct and then being suspended, reinstated again. Just talk us through, how the department, importantly, will then have to defend, that accusation by the SGB.
So my understanding is the mandate was strictly to investigate allegations of racism. They subsequently went beyond that. I think one of the examples that's been proffered at this stage is that white colleagues haven't been greeting black colleagues, and they've tried to tie that into this report. If it's simple, if there's no supporting evidence that there has been racism or these allegations of racism are in fact true, they would then need to completely halt their investigation, because the mandate has then been fulfilled. To go beyond the scope is, you simply cannot do that. You need to stick within the parameters of your mandate. And I mean, if it is found that they did go beyond the parameters of the mandate, then they would need to answer to that.
And would they at the same time be then compelled to release the investigation or the report, at least, into their investigations, which probably would uncover if indeed that scope was expanded?
Definitely. And it goes back to what I'd said previously is, first of all, the SGB would need to obtain a full copy of this report before they can proceed to review the report and possibly set it aside. And in order for them to determine whether, the GDE acted beyond the scope of their mandate.
And I know I might be just, looking too much ahead into the case, but in this particular matter, how important is it for the legal process to consider both the allegations of racism and the broader issues that have been raised, particularly by some of the victims and, of course, the department in its investigation, such, of course, as the principal's actions and the handling of the WhatsApp group by the school and the SGB's involvement too. I mean, how could this affect future cases involving school misconduct, particularly this one?
I do believe that obviously this is a very serious matter, and that, matters like these need to be treated with the sensitivity that they deserve and the importance that they deserve. However, if for example, in this matter, the 12 pupils were found not guilty of misconduct, you need to take that into consideration. Proper disciplinary steps need to be put in place in order to identify whether there is misconduct. And if they are guilty, then, the legal process must take its course. But I think it's important for us to remember that you need to determine whether the parties or party are guilty versus not guilty, and then sort of take the necessary steps from there. I think schools need to remember that, this is a sensitive issue and it needs to be dealt with properly. And if it isn't dealt with properly, there are severe and far-reaching consequences.
Geraldine, thank you so much for unpacking that for us. It is obviously a very complex matter, and we await to see what the outcome is, or in fact how this will be handled in court. Thank you so much, Geraldean Dawes, the Senior Associate at the Ulrich Roux and Associates.